Section 24. Deficiency Judgments and Arizona's Anti-Deficiency Protections. David asks the $100,000 question. We're still following the alternate ending to David's Queen Creek story. His short sale failed. He could not reinstate the loan. And now he is imagining the worst-case scenario. He owes approximately $500,000 when all applicable amounts are considered. And he worries that the property might produce only $400,000 in a foreclosure sale. David looks at Ashley and says, "So if they're short $100,000, are they going to sue me for $100,000? Ashley remembers something she heard years ago and almost says, "No, Arizona is an anti-deficiency state." Michael stops her. That sentence is exactly how agents get themselves into trouble. Arizona does have significant anti-deficiency protections, but that does not mean every borrower, every property, every loan, and every foreclosure automatically receives identical protection. Let's start with the basic concept. A deficiency can arise when the amount legally credited from the foreclosure process is insufficient to satisfy the secured obligation and applicable amounts due. Suppose, purely for illustration, a borrower owes $500,000 and the legally applicable credit after foreclosure is $425,000. There appears to be a $75,000 difference. The next question is not simply, how does the lender collect the $75,000? The next question is, does Arizona law permit the lender to recover that deficiency under these circumstances? That's where the anti-deficiency statutes become extremely important. The trustee's sale protection. ARS Section 33-814 contains Arizona's deficiency rules involving property sold under a deed of trust through the trustee's power of sale. One of its most important protections appears in subsection G. If the trust property is 2 1/2 acres or less, and is limited to and utilized for either a single one-family or single two-family dwelling, the statute provides that no action may be maintained to recover the difference between the sale proceeds and the indebtedness, interest, costs, and expenses. That sounds powerful because it is. But notice the statutory language. Property size matters. The type of dwelling matters. How the property is utilized matters. And subsection H contains exclusions for certain deeds of trust originated after December 31st, 2014. Including specified builder-owned properties, dwellings never substantially completed, and dwellings intended for residential use but never actually utilized as dwellings. This is why Ashley should never reduce the law to, it's a house in Arizona, so you're protected. What if the protection doesn't apply? Suppose the facts do not fall within the statutory protection. That still does not mean the lender can wait indefinitely. ARS Section 33-814 generally provides a 90-day period after the trustee's sale to maintain an action for a deficiency, when such an action is legally available. The statute also uses a fair market value calculation. The deficiency is not necessarily determined merely by subtracting the auction price from the debt. The court considers the greater of the sale price or the court-determined fair market value as provided by the statute. Imagine a property with a fair market value of $450,000. Is sold at a trustee's sale for $350,000. When a deficiency action is otherwise permitted, the statutory calculation does not necessarily allow the creditor to treat that $350,000 auction figure as the only value credited against the debt. Again, this is legal analysis, not something Ashley should calculate for David on a listing appointment. What about judicial foreclosure? Now let's make the story more complicated. David asks, what if they foreclose through court instead? Excellent question. Arizona also has anti-deficiency provisions involving certain purchase money mortgages. ARS Section 33-729 generally provides important limitations when a qualifying mortgage secures the purchase price, or a loan used to pay all or part of the purchase price for qualifying residential property of 2 1/2 acres or less. But notice what we're doing again, identifying the statute that applies to the actual foreclosure method and loan. We are not taking one rule and applying it to every distressed homeowner. Judicial foreclosure and a trustee's sale are different procedures. Purchase money and other debt can present different questions. Property characteristics can matter. That's why Michael refuses to give David a one-sentence legal conclusion. The most dangerous phrase, "You're fine." Imagine Ashley tells David, "You're fine. They can never come after you." David relies on that statement and decides not to consult an attorney. Months later, he learns that the facts of his particular loan or property create an issue Ashley never considered. Her reassuring sentence has now become part of a potential complaint. AAC R4-28-1101 requires Arizona licensees to protect and promote their clients' interests while performing their duties. Protecting a client does not mean pretending to know every answer. Sometimes protecting the client means recognizing that the question has moved from real estate brokerage into legal analysis. Ashley can explain the general concept of a deficiency. She can explain that Arizona has significant anti-deficiency statutes. She can identify that different foreclosure methods can produce different consequences. Then she can say, before you make a financial decision based on whether you could remain personally liable, you should have an Arizona attorney review your specific situation. That's professional representation. Chapter 5 comes full circle. Michael closes David's file and looks at Ashley. What did this teach you? Ashley answers that foreclosure isn't one event. It's a process. I need to know whether we're dealing with a trustee sale or judicial foreclosure. Watch the notice and sale dates, understand reinstatement, and recognize that redemption and deficiency rules depend on the actual situation. Michael smiles. Exactly. And what do you do when the answer becomes legal advice? I stop guessing. That may be the most important lesson in the chapter. We've now studied contracts. We followed David through a short sale. Then we rewound his story and followed the foreclosure path he narrowly avoided. In Chapter 6, we're bringing all three together. We'll examine what happens when a distressed property transaction collides with contract deadlines, disclosure duties, buyer protections, changing circumstances, and the agent's responsibility to protect the public. We begin with Section 21, when foreclosure and the purchase contract collide. Online discussion. 1. David asks Ashley whether Arizona's anti-deficiency laws guarantee that he can never be personally responsible for a shortage after foreclosure. What should Ashley say? Answer. Ashley should explain that Arizona provides significant anti-deficiency protections, but their application depends on facts, such as the foreclosure method, property characteristics, loan structure, and other circumstances. She should not guarantee protection and should recommend that David obtain qualified Arizona legal advice before making decisions based on potential liability. 2. Why is saying Arizona is an anti-deficiency state insufficient advice for a distressed homeowner? Answer. The statement oversimplifies multiple statutes. ARS Section 33-814 governs important deficiency issues involving deeds of trust and trustee sales, while ARS Section 33-729 addresses qualifying purchase money mortgages in a different context. The property's characteristics and foreclosure method can materially affect the analysis. 3. Why can fair market value matter when a deficiency action is legally permitted after a trustee's sale? Answer. ARS Section 33-814 provides a fair market value framework that generally credits the borrower with the greater of the trustee's sale price or the court-determined fair market value when calculating an allowable deficiency. This can prevent an artificially low auction price from automatically determining the amount of the deficiency.